Did you know that the tax authorities in the Netherlands had used a self-learning algorithm to create risk profiles to spot childcare benefits fraud? The algorithm was programmed to identify suspicion of fraud on the basis of certain risk indicators, including dual nationality and low income. As a consequence, many families, often with lower incomes or belonging to ethnic minorities, were discriminated by being wrongfully suspected of fraud and pushed into poverty. Their rights of non-discrimination, access to social assistance and to justice have been violated. Or have you heard about the US company Clearview AI, which built an enormous database of pictures scraped from social media and then used by law enforcement agencies around the world to identify alleged criminals? In this case, rights such as privacy and data protection are at stake, as well as the right to a fair trial. Clearview AI has been fined by several European data protection authorities, but without a physical presence of the company in the EU, it is difficult to enforce these decisions. In this video today, we will talk about the impacts that the use of AI systems can have on fundamental rights. We will learn what a fundamental right is, how it is protected, why AI systems challenges fundamental rights protection, and which safeguards the European Union, the EU, is putting in place to tackle these challenges. We will focus on the European Union legal framework. So, first of all, to understand the impacts that AI systems can have on fundamental rights and why, we need to grasp what a fundamental right is. Fundamental rights are the foundational rights of each individual, originating from human dignity and allowing the overall flourishing of the human being. They are enshrined by the Charter of Fundamental Rights of the EU, the so-called EU Charter, and by the national constitutions of the member states. Indeed, fundamental rights are so important that they are protected by the laws of the highest hierarchy within the EU legal system, known as primary law. Examples of fundamental rights enshrined by the EU Charter are the right to life and to the integrity of the person, the right to liberty and security, but also the right to privacy, to freedom of expression, to information, the right to non-discrimination, to social security and social assistance, to healthcare and to justice. Fundamental rights are not static. Their interpretation and application by the courts evolves through time to reflect societal changes, and new rights can be officially recognized as fundamental, as it recently happened with the right to abortion added in the French Constitution. But why fundamental rights are fundamental? That is, how is a fundamental right different from other rights and how it is protected? First, as I said before, fundamental rights are protected by the laws of the highest hierarchy within the EU legal system, the primary law. Primary law is typically abstract and serves to establish the core principles on which all the other laws of the legal system must be based. Fundamental rights are therefore not always defined with sufficient precision. Often, secondary laws, lower in hierarchy, are necessary to enact fundamental rights identified by primary law. Second, fundamental rights traditionally regulate the relationship between public powers and citizens, rather than the relationship between private parties. So, now that we understood what a fundamental right is and how it is protected, we can better understand why AI systems challenge traditional fundamental rights protection. The core capability of AI systems is to analyze vast amount of data, called input, according to specific criteria. The criteria can be defined by the programmers at the outset or inferred by the AI system itself. These criteria are then used to organize and derive information from the input, referred to as the output. But how does this way of functioning of AI systems pose challenges to the protection of fundamental rights? So the inherent logic by which an AI system operates and the criteria used to come to a certain output are often difficult for human beings to unravel and are based on the vision of reality that the AI system embeds, which comes from those who program it. So let's make an example. Let's go back to the Dutch childcare benefits scandal I mentioned at the beginning. The authorities believed that low income and dual nationalities were valid criteria to identify fraud. So the AI system they used embeds this vision and applies it on a massive scale. As a result, these criteria perpetrated direct discrimination towards families with low income and belonging to ethnic minorities, which were excluded from the enjoyment of social assistance precisely because they belonged to specific groups. Elaborating AI systems operating according to fair criteria and with access to complete and accurate past data is a big challenge in practice. It means gathering all the relevant data, using them lawfully by, for instance, respecting privacy or confidential information, and elaborating non-discriminatory and inclusive decision-making criteria. Additionally, we should consider the scope of application of AI systems. The fact that AI systems are present in almost every sphere of life can impinge on a wide array of fundamental rights. Also, there are fundamental rights that almost always come into play. It is the case, for instance, of the rights to privacy and data protection triggered by the reliance of AI systems on past data to operate, but also the right to non-discrimination, which is often interfered by the incomplete, inaccurate, or biased data or AI models. In essence, on the one hand, the structural way in which AI systems operate continuously impact on multiple fundamental rights. On the other hand, fundamental rights are formulated in form of general principles by primary laws, which needs to be enacted by secondary legislation to be applied and are mainly addressed at public powers. So, all these conditions create a lack of protection for individuals and for societies. But which safeguards the European Union is putting in place to tackle these challenges? The digitalization is changing fundamental rights protection, since private actors such as big platforms and tech companies are increasingly called by the EU legal framework to directly respect fundamental rights as they accumulated powers and perform functions comparable to those traditionally exercised by public authorities. The EU has passed laws such as the General Data Protection Regulation, the so-called GDPR, which obliges private companies and individuals to process personal data according to specific principles and procedures to preserve the fundamental right of data protection. In the same way, the Digital Service Act, so-called DSA, obliges certain private actors, including online platforms, to respect fundamental rights, such as freedom of expression. The newly adopted AI Act goes in the same direction by prohibiting AI systems that pose unacceptable risks to fundamental rights and requiring providers, but also professional users, to assess and manage the risks to fundamental rights posed by certain AI systems, classified as high risk. But besides the new laws, fundamental rights have been applied in the relationship among private parties thanks to the rulings of the European Court of Justice, which is the highest court in the EU, and thanks to already existing secondary laws. It is the case of the non-discrimination directives, which enacted the right to non-discrimination in specific sectors, for instance, establishing the prohibition of discrimination based on sex and race in the access to goods and services. Also, the EU is adjusting existing legal instruments to tackle the new challenges, for instance with specific liability rules for the compensation of damages caused by AI. So, to sum up, we learned what a fundamental right is, how it is protected, why AI challenges the traditional protection of fundamental rights, and what is the reaction of the EU legal system. We have some general conclusions. First of all, fundamental rights are interfered in new ways by AI because of the way AI systems operate and because of their use in every sphere of life. Some rights are particularly at stake, as the right to privacy and data protection and the right to non-discrimination. Second, understanding which rights are impacted and how is not straightforward because fundamental rights are typically abstract and are mainly addressed at public powers. So the EU legal framework is changing to tackle these challenges, but in the new laws, such as the DSA and the AI Act, fundamental right protection remain rather general. Finally, I'd like you to leave this video with two ideas. First, new obligations are imposed on private actors to protect individuals against the risks to fundamental rights. Second, we expect an evolution of the mechanism of protection of fundamental rights and new interpretations of their scope. The AI Act alone cannot address all these challenges. Other legal instruments are needed, such as adapted liability rules for the compensation of damages caused by AI. Still, the AI Act is a great experiment. If and to what extent will be effective is to be seen in the following years.